What happens when the person in charge of being the top federal prosecutor in a really critical district is just deemed illegitimate by the courts?
Well, it's not some abstract legal problem. I mean, it's an immediate, profound threat to public safety.
A threat how?
We're talking about whole stacks of serious criminal cases, from national security to, massive defense fraud, suddenly being vulnerable.
Vulnerable to just being thrown out.
Exactly, thrown out. We're talking about mass dismissals that defendants, even those involved in some of the most serious felonies you can imagine, are just waiting to exploit.
Okay, so let's really get into this. We're looking at a story of what our sources are calling a quiet surrender by the Department of Justice.
A surrender where they basically conceded that their attempts to install political operatives in these critical federal prosecutor roles were unlawful.
But the chaos they left behind is anything but quiet. We have sources detailing how political expediency just completely trumped legal standards.
And the result is a judiciary that has been forced to issue what are, for all intents and purposes, eviction orders.
Eviction orders. Yeah. For a U.S. attorney. That's incredible.
It is. So our mission today is to really analyze the fallout from this failure to stick to the rule of law when it comes to appointing U.S. attorneys.
And the core issue seems to be this systemic corrosion caused by a partisan strategy.
A strategy that was designed from the ground up to bypass the constitutional requirement of Senate confirmation.
So we're going to be looking at specific court rulings that have declared interim U.S. attorneys to be, in the court's words, unlawful.
Creating a legal jeopardy so massive that it threatens the integrity of the entire federal docket across multiple jurisdictions.
We'll look at the severe legal implications, the systemic risks, and frankly, the jaw-dropping lack of qualifications displayed by some of the key appointees.
This isn't just about politics. This is about the very foundation of the American justice system being compromised from within.
So to really understand the depth of this crisis, we have to start with the basic rule, right? The legal mechanism for appointing these U.S. attorneys.
Exactly. And the rule is deceptively simple. It's all designed to uphold the separation of powers.
So tell us about that rule, because that's the specific boundary the Trump administration is accused of repeatedly crossing.
The rule says the president gets one shot, just one shot at appointing an interim U.S. attorney.
And that power only exists under certain conditions.
Correct. It's only when the Senate is in recess or has failed to confirm a nominee. It's meant to be a temporary measure, just to keep the lights on and the cases moving.
Historically, it wasn't used as a political weapon then.
No, not at all. It was used judiciously with respect for the Senate's constitutional role of advice and consent.
So if the Senate rejects a nominee, or if that initial 120-day interim period runs out, the president's power just stops.
It ceases. And the next in line should be the local federal court. The court then appoints a replacement to ensure legal continuity.
And that's the design, right? To stop the president from just perpetually installing their own person without any democratic scrutiny.
Precisely. The system is engineered to prevent exactly that kind executive overreach.
But the violation here was, it was a wholesale.
Absolutely. The Trump administration appointed multiple so-called fake interim United States attorneys, violating this established legal limit not just once, but repeatedly in several key districts.
They treated the one-shot rule like an endless supply of bullets.
That's a good way to put it. They were just cycling through political placeholders who hadn't been and likely could never be confirmed by the Senate.
It sounds like a deliberate effort to keep politically aligned people in these crucial positions of power.
And to do so while actively bypassing the entire constitutional vetting process.
But hold on, why did the judiciary have to get involved so severely? Couldn't the Department of Justice just have said, oops, our mistake, and revoke the appointment themselves?
That's what you would expect from an institution acting in good faith. But that's not what happened.
So they pushed it.
They pushed it. And that's the crucial element here. Institutional defiance. They knew these appointments were legally dubious, but they believed they could operate in that gray area until they got what they wanted politically.
But the courts saw right through it.
The courts saw this maneuvering for exactly what it was, a blatant attempt to nullify the Senate's constitutional role.
And that's when the judiciary struck back, and struck back hard.
Yes, by declaring these appointments unlawful. We saw specific rulings that deemed appointees like Lindsay Halligan in the Eastern District of Virginia and Alina Habba in New Jersey as having no legal authority whatsoever to hold the office.
These rulings are a powerful statement then.
Oh, they're a huge statement. They're the court saying they will not tolerate the erosion of constitutional checks and balances.
So once the courts declared them unlawful, the appointees were legally disqualified. But here's where the story gets even more audacious.
It really does. Look at the specific example of Alina Habba in the Third Circuit Court of Appeals. She was disqualified, but the administration actually argued that a ruling of disqualification didn't automatically mean they had to, leave the building.
Wait, what? They were essentially arguing, you said we're illegal, but you didn't say we had to leave.
That's precisely the argument. It sounds like something a child would say, a misreading of a clear judicial order.
It's more than childish, though. It's institutional defiance that borders on contempt of court.
It absolutely is. And it forced the circuit courts to issue explicit, formal, and I have to imagine rather exasperated eviction orders.
The judges had to actually spell it out for them.
They had to spell it out. They had to say, yes, when we ruled you were disqualified and unlawful, we meant you must cease all prosecutorial duties immediately and vacate the premises.
That is just astonishing. The idea that federal judges have to write an official order telling a U.S. attorney, the chief federal law enforcement officer in the district, to get out because they're an illegal squatter.
It says everything about the state of institutional integrity at that time.
And this wasn't an isolated incident.
Not at all. The source notes that similar legal proceedings were happening over in the Ninth Circuit. This wasn't a one-off mistake in New Jersey or Virginia.
So it was a pattern.
It was a broad, systemic strategy across the country by the regime to keep unconfirmed political allies in place while actively avoiding the legally mandated Senate process.
And the courts had to step in as the last line of defense for the rule of law.
They were the ultimate protectors of the structural rule of law in this case.
So the judiciary forced their hand, and this political strategy became a huge legal liability. And this is what brings us to the quiet surrender.
Exactly. When the judicial pressure became completely overwhelming, the Department of Justice finally began, as the sources describe it, yielding to the law.
And crucially, they did it silently.
Oh, very quietly. There were no press releases apologizing for violating the law or admitting their strategy had failed. They just quietly folded when faced with the absolute certainty that the federal court system would otherwise grind to a halt.
Because of the number of cases they were invalidated.
Correct. This quiet concession was the only way they could minimize the political embarrassment.
And the maneuver with Lindsay Halligan in Virginia is the perfect example of this. This political retreat disguised as a dignified exit.
This peace with honor strategy, as the source calls it.
Despite being ruled unlawful and disqualified by the courts, she just quietly submits her name to the Senate for formal confirmation.
It's a clear attempt to square everything and make it kosher. Or, to put it less delicately, to launder the illegal appointment through a legitimate, albeit completely doomed, process.
By submitting her name for confirmation, they can claim they're now playing by the rules.
Even though the only reason they're at this point is because the courts had already ruled her entire tenure was illegal from the start.
So it gives them a political talking point. See, we are engaging with the Senate process.
But it's a gesture made entirely under duress. It's not a serious attempt at confirmation. It's political posturing designed for an audience of one.
Allowing the administration to save face publicly while privately admitting defeat to the courts.
The irony is just so rich. They spent months subverting the constitutional process only to be forced right back into that very process by the threat of total judicial chaos.
This quiet retreat really shows that even when political actors try to disregard the rules, the federal judiciary can still enforce the fundamental structures of government.
They had to retreat, not because they wanted to, but because the alternative was the collapse of their own legal enforcement arm in major districts across the country.
Okay, here's where the story pivots from these, legal mechanics to what feels like real institutional outrage.
Yeah.
We have to talk about the person at the center of this, Lindsay Halligan.
And specifically, her resume for the U.S. attorney role, the chief federal prosecutor in one of the most important districts in the entire country.
The Eastern District of Virginia, the EDVA.
And her resume was, according to our sources, threadbare to the point of being genuinely shocking.
Let's put that in context. Why is the EDVA so important?
It's known as the rocket docket. It moves incredibly fast and handles some of the most critical national security cases in the country: espionage, military contractor fraud, high-level cybercrime.
All because of its proximity to Washington, D.C., the Pentagon, all the intelligence agencies.
And numerous defense contractors. It requires a prosecutor with a deep, specialized understanding of federal law interagency relationships, and crucially classified proceedings.
So what was the background of the person chosen to oversee this immense responsibility? I mean, detail this lack of experience for us, because it really does defy belief.
Her professional history is just astonishingly thin for this kind of role. Her primary background was as an insurance attorney.
An insurance attorney.
Yes. She dealt with civil litigation, specifically coverage disputes. It's a world away from grand juries, RCO cases, and national security warrants.
And before that?
Before that, she was a beauty pageant contestant.
So an insurance attorney who, according to the source, never worked in a federal prosecutor's office in her life, is suddenly appointed to manage dozens of career federal prosecutors.
And enforce federal criminal law in one of the nation's busiest and most sensitive jurisdictions.
How does someone with zero federal experience even begin to navigate the high-level security clearances, the classified information, the relationships with the FBI, the CIA?
The institutional shock inside that office must have been immense. A typical U.S. attorney's career path revolves clerking for a federal judge, maybe even a Supreme Court justice.
Right, then years as an assistant U.S. attorney, handling complex trials, rising through the ranks.
And demonstrating an unwavering commitment to nonpartisanship. Halligan skipped every single one of those required steps.
The source notes she wasn't even known as a particularly good lawyer in her own field.
No cases of note. She was simply viewed by the wider legal community as, who is this person?
That contrast alone just underscores that competence was clearly not the main criterion for this appointment.
No, which leads directly to the issue of her alleged political mandate.
Exactly. The sources state very clearly that she worked her way into Trump's world and was picked specifically to target and go after political enemies.
And they name names. New York Attorney General Letitia James and former FBI Director James Comey were specifically mentioned.
So her role wasn't to perform justice impartially. It was purely partisan enforcement.
That's the allegation. The source even suggests that if you viewed her brief, disastrous tenure as a trial audition for the permanent job,
she failed spectacularly.
She couldn't have done a worse job and made every mistake. That sounds less like a simple failure of competence and more like an active demonstration of being fundamentally unprepared for the gravity of that position.
The combination of inexperience and partisanship is just completely untenable in a role like this.
When you lack the basic legal knowledge to run a massive federal office and your primary motivation is political loyalty, the outcome is predictable.
A legal and ethical catastrophe.
Precisely. And that takes us back to the sheer arrogance of submitting her name to the Senate for confirmation after the courts had already ruled her entire tenure was illegal.
The source used extremely strong language here, calling this the biggest FU to our justice system. We have to analyze why that phrase was chosen.
The language is powerful because it highlights the insult to the entire institutional process. Submitting her name suggests a belief that sheer political will can just override judicial findings of illegality.
It treats the Senate confirmation process, which is supposed to be the ultimate check on executive power, as just political theater.
Exactly, and you have to imagine what that political theater would actually look like.
The Senate confirmation process, especially for a U.S. attorney, is incredibly rigorous. There's a detailed questionnaire from the Senate Judiciary Committee.
It is a massive undertaking. She would be required to list her 5 or 10 most important and pertinent cases relevant to her fitness for the role.
And given her background,
Yeah.
what would she list?
Well, the source speculates that because her federal experience is 0 and her civil experience is threadbare, her list might potentially include nothing more than an insurance coverage involving the dog in the Buick.
Let's just pause on that image for a moment. An insurance case about a minor accident. A dog running into a Buick. Being presented as evidence of her fitness to prosecute international espionage in the EDVA.
The sheer absurdity of it just highlights the vacuum of experience they were trying to fill with pure political loyalty.
It's politically farcical, but it's institutionally devastating.
It's a public, documentable humiliation of the professional standards of the Department of Justice. Any serious nominee would submit years of complex trial victories, appellate work, managerial experience.
Her submission would just be an empty shell.
An empty shell. And on top of that, the nomination is DOA, dead on arrival, because of a critical political barrier.
The blue slip process. We need to detail this because it's the ultimate protection against this type of partisan appointment.
The blue slip is a critical Senate tradition. It grants immense power to the home state senators regarding federal, judicial, and prosecutorial nominees.
When the nomination paper is circulated, there's literally a blue slip of paper for the senator to sign. indicating their approval.
Exactly. And in this case, the two Democratic senators in Virginia, Tim Kaine and Mark Warner, will undoubtedly exercise their power to withhold that slip.
And without the support of the home state senators, the Judiciary Committee chairman traditionally will not even hold a hearing or a vote on the nominee.
Precisely. There is zero chance that they both submit their blue slips, which means the nomination cannot move forward. It's a simple procedural kill switch.
So, if they know the nomination is doomed, why would they go through the public humiliation of submitting a threadbare resume? What's the point?
It is purely for political posturing. The nomination allows the administration to just whine when the Senate inevitably blocks it.
It provides political cover.
Exactly. An opportunity to rail against the confirmation process and the Democratic senators claiming they're obstructing justice for partisan reasons.
Rather than admitting that the judicial rulings, which declared their initial appointment unlawful in the first place, were correct.
The submission is a political spectacle. It's designed to create talking points for the base, not as a serious attempt to confirm a qualified prosecutor.
Okay, we have to transition now from this discussion of qualifications to specific allegations of deliberate, profound misconduct that allegedly occurred during Halligan's unlawful tenure.
And this is where the story gets much darker. The sources move past mere incompetence and describe her actions as malicious and, quote, in my view, deeply unethical behavior.
That shifts the narrative from a legal technicality to a potential criminal subversion of the justice process itself.
These are incredibly grave allegations because they strike at the absolute core of a prosecutor's duty to the grand jury.
Explain that role.
A prosecutor has a unique role in that context. They are the legal guide for the grand jury, an institution that's meant to be an independent shield between the government and the accused.
So the prosecutor has to present evidence and the law impartially.
They must. When a prosecutor acts maliciously, they are abusing that sacred position of trust to achieve a specific outcome, regardless of what the evidence or the law actually says.
So let's get into the specifics. The shocking examples of alleged constitutional errors and misconduct made within the grand jury process itself. The source gives 3 points of failure. First, the tainted witness.
This is a fundamental first-year law school error. She is accused of putting on a witness in the grand jury who was compromised because they had seen attorney-client information.
That information is supposed to be sacrosanct. It's privileged.
It is. If the witness saw privileged communications related to the target of the investigation, that witness's testimony is tainted and the entire proceeding could be compromised.
That's a massive breach. If an indictment is based, even partially, on information they got by unlawfully breaching privilege,
it renders the entire case fundamentally flawed and, very likely, dismissible.
And this leads to the second, even more alarming allegation, providing fake legal instructions to the grand jury.
We need to be very clear about what this means. The grand jury operates without a judge in the room. They rely entirely on the prosecutor to instruct them on the law, what constitutes the crime, what the elements are, and the standard of probable cause they must meet.
So if the prosecutor provides fake instructions, they are fundamentally misleading the grand jury about the law itself.
Yes, they're twisting the legal framework to fit their desired outcome.
How would proper instructions differ from these alleged fake ones?
Proper instructions are dispassionate recitations of the statute and judicial precedent. They must be neutral and balanced. A prosecutor must instruct the jury on probable cause, what it requires, and so on.
And fake instructions?
Fake instructions might manipulate that standard, maybe making it sound easier to indict than the law allows, or twisting the definition of the crime to specifically capture a political opponent's behavior.
So, in effect, the prosecutor is turning the grand jury, which should be an independent body, into a rubber stamp.
A rubber stamp guided by misinformation, all designed to reach a predetermined political outcome.
That allegation, more than any other, speaks to foundational ethical malfeasance.
It's not a procedural error. It's a deliberate attempt to corrupt the very mechanism of justice for partisan gain.
And the third allegation relates directly to her alleged political target, the indictment relating to James Comey.
And this one is perhaps the most shocking shortcut of all.
The allegation is that she submitted the indictment as though it was the true bill, when the full grand jury never even saw it.
This suggests outright fraud upon the court. The true bill is the official document signed by the foreman of the grand jury that formally confirms the grand jury has voted to bring charges.
It's the physical manifestation of the grand jury's constitutional consent.
Right. If the full grand jury never saw or formally ratified that document and the prosecutor submitted it anyway,
That's an attempt to substitute the prosecutor's will for the constitutional power of the citizens serving on that grand jury.
it is a profound violation of the grand jury's role. It strips away that constitutional check and makes the prosecutor the sole arbiter of who gets charged. It is a catastrophic ethical violation.
It's just stunning that all of these specific, detailed allegations of misconduct, the tainted witness, the fake instructions, the false true bill, never led to any official judicial sanction against her.
How did these lapses just get ignored by the courts?
That is what the source refers to as Halligan's good fortune. It was her escape hatch.
What does that mean?
She was ultimately disqualified and removed by the courts solely on the grounds of being an unlawful interim U.S. attorney. The procedural irregularity of her appointment was so fundamental and so severe that they didn't need to get into the factual allegations of misconduct.
So the courts didn't get to rule on all that other unethical stuff.
Exactly. The legal technicality of her being an illegal squatter was so overriding that it bypassed the need to conduct a deep public inquiry into her alleged ethical violations.
Which would have required months of motion practice and potentially exposed the DOJ to severe public embarrassment.
Correct. And while this ensured her immediate removal, it meant the full seriousness of the ethical lapses. The deliberate attempts to undermine the integrity of the process were never formally judged or documented in a judicial opinion.
So it's a bitter kind of relief.
A bitter relief that the procedural fault was sufficient to protect the integrity of the docket, even if the ethical failures went unpunished by the court itself.
The ultimate implication of all these unlawful appointments is the systemic risk they created. It goes way beyond one person.
Right. When a U.S. attorney is deemed a nullity illegitimate, it means, as our source says, every indictment that you oversee is in some peril.
And this is what moves the issue from a political drama to a direct threat against law enforcement outcomes and, critically, public safety.
This is the core reason why the DOJ ultimately had to retreat, isn't it?
It's the only reason. The legal vulnerability created by an unlawful prosecutor is deep and systemic. Defendants suddenly have an immediate, powerful defense strategy.
Based on the legal principle known as the doctrine of nullity.
That term nullity needs a clear explanation. Why would the actions of one prosecutor make the entire indictment a legal nothing?
Think of it this way. Imagine you hire a contractor who isn't legally licensed to build the foundation for a skyscraper. Even if the materials are good, the entire structure is legally questionable because the authority of the builder was void from the start.
The structure is a nullity.
Precisely. So in this context, defendants can now use what the source calls the Alice in Wonderland defense. They argue that if the overseeing prosecutor was a nullity, a legal nothing, then the indictment they supervised is also void.
So defendants, including those charged with really serious crimes, can just walk into federal court and say, the person who brought these charges against me had no legal authority to do so.
Therefore, the charges are void, regardless of the evidence.
And the consequence for the Department of Justice is just catastrophic. The defendant could go free and we start again.
Which means mass dismissals are possible. Or at the very least, the government is forced to redo thousands of hours of complex investigatory work.
Grand jury proceedings, motion practice, all while the statute of limitations is ticking down on some very serious crimes.
This represents a massive cost to public safety, especially in a district like the Eastern District of Virginia.
We need to really elaborate on the specific types of high-stakes, time-sensitive cases that were hanging in the balance there.
The EDVA is not dealing with petty crimes. It handles a high volume of crucial federal cases. We're talking about national security matters, counterterrorism, espionage cases coming out of the nearby intelligence agencies.
We're discussing large-scale defense fraud involving billions of dollars in government contracts, or massive organized drug trafficking rings.
And these are cases that rely on timely grand jury proceedings, sealed indictments, and the immediate legal authority of the U.S. attorney to get warrants and cooperation.
Exactly. To have the legal uncertainty caused by an unlawful appointment hanging over every single one of those cases brings whole offices to a stop.
Federal agents suddenly lose confidence in the validity of the legal paperwork they're pursuing.
The prospect of mass dismissals in such critical areas where letting a defendant go free and start again might mean losing a vital intelligence operative or missing the statute of limitations on a 10-year fraud scheme, That's what truly terrified the institutional DOJ.
That internal threat to their operational capability forced their hand far more effectively than any public political outcry ever could.
They just couldn't afford the public safety costs of continuing to ignore the judicial rulings. The courts made it clear.
What did they make clear?
That if the executive branch failed to yield, they would continue to issue rulings that would invalidate cases, leading to a catastrophic collapse of the federal court system in that jurisdiction.
The sources note the DOJ had to recognize they just can't do it.
The risk was no longer just to a political appointee's ego. The risk was to the entire national security docket.
I think that's the true measure of the failure here. Their own reckless political strategy created a legal risk so profound that it ended up protecting defendants accused of severe crimes.
It forced the DOJ to quietly retreat because the costs, the chaos, and the threat to public safety became far too high. They were essentially protecting the system from the very people they illegally installed.
So if we zoom out a bit, the most profound and frankly lasting consequence of this whole saga is the damage that was inflicted on the reputation and the credibility of the Department of Justice.
Especially in the eyes of the people who matter most in that context, the federal judiciary.
The U.S. attorney position requires a very specific ethos, one that is the absolute opposite of the actions we've just been discussing.
It requires performing justice without fear or favor. A successful career path is designed specifically to ensure that the individual is committed to nonpartisanship.
The U.S. attorney must be viewed by the court, by the bar, by the public, as the embodiment of unbiased justice. They are not political operatives.
They're institutional leaders. The traditional path involves decades of rigorous experience, developing prosecutorial skill, and demonstrating a deep understanding of constitutional law.
All to insulate them from partisan influence.
Precisely. But what we witnessed with these appointments was the deliberate contamination of that ideal, the combination of inexperience and partisanship in the Donald Trump model.
The sources call this the antithesis of what U.S. attorneys are supposed to be.
It is. It's the systemic prioritizing of political goals over legal standards. And you have to contrast this with historical standards.
Go on.
Take Justice Alito, who served as U.S. Attorney in New Jersey. A regular guest on one of the Source podcasts, who served as Alito's first assistant, said that during their time working closely together, they never even knew what party he was.
That's the expected standard.
That is the standard. The commitment is solely to the facts and the law, not to the political machinations of the day.
But the appointments we've analyzed actively embraced a political mandate. They made their intentions public.
The Alina Habba example provides the most egregious statement of intent. It undermines the very foundation of the office before she even signed a single document.
Remind us what she said.
When Alina Habba was chosen for the U.S. Attorney role, she stated publicly, "I hope I can use this position to help turn New Jersey red."
That one statement should be immediately disqualifying for a prosecutor.
Absolutely. The job is nonpartisan. Announcing a political goal like turning New Jersey red fundamentally politicizes a role that must be above the partisan fray.
It's an admission that the primary objective was political gain, not dispensing justice according to the law.
And when a prosecutor demonstrates such clear bias or such a profound lack of qualification combined with alleged ethical misconduct like providing fake legal instructions, what is the ultimate long-term cost?
The ultimate cost is the loss of critical trust among the federal judiciary.
That's it. The sources describe how the actions of these appointments have so degraded the reputation of the Department of Justice that federal judges now view the DOJ as, and I'm quoting here, basically some scammy law firm at this point, unfortunately.
A scammy law firm. That is a devastating, almost unprecedented assessment coming from the federal bench.
A bench which traditionally holds the Department of Justice in very high regard, assuming its professionalism and its integrity.
It implies a presumption of bad faith, doesn't it?
It does. When a judge receives a filing from the U.S. Attorney's Office, an office that should be above reproach, and their first thought is that this filing might be a politically motivated stunt or a corner-cutting maneuver.
That cripples the functioning of the entire court.
Federal judges are now viewing the DOJ's submissions, motions, and arguments with a heightened level of suspicion, a presumption of partisanship rather than a presumption of integrity.
And once that judicial trust is lost, it doesn't just affect one case. It affects the efficiency and fairness of the entire federal docket.
Every future motion, every plea negotiation, every argument from the DOJ will be weighed against this memory of fake legal instructions and unlawful appointees.
Rebuilding that reputation with the judiciary will take years, maybe decades.
And that is the quiet, lasting damage. The political players move on, but the institution itself, the federal system of justice, is left to grapple with the profound loss of credibility caused by prioritizing party loyalty over professionalism and legal integrity.
So this quiet surrender, this forced retreat by the Department of Justice, it isn't just about a few failed nominations or some temporary legal setbacks.
No, it's about the profound institutional damage caused by prioritizing political bidding over core legal standards and institutional integrity.
The judiciary was forced repeatedly to step in to protect the system from a potential collapse.
To secure public safety by effectively forcing the executive branch to walk back a completely untenable, legally fraught strategy. They gambled the rule of law for short-term political appointments, and they lost spectacularly.
The combination of lack of experience and partisanship that defined this strategy proved to be completely untenable the moment it faced any kind of serious legal scrutiny.
And the retreat demonstrates that even the most determined political actors have to yield to judicial pressure when the cost becomes the fundamental breakdown of the rule of law itself.
Threatening national security and public safety cases across the country.
When you have circuit courts issuing eviction orders to chief federal prosecutors, and the DOJ risking the dismissal of major fraud and espionage cases, the system has reached a critical failure point.
It took the judiciary stepping up to enforce those constitutional boundaries to stabilize a situation that the executive branch had destabilized through sheer disregard for the legal process.
We often think about political damage in terms of polls or legislation, but consider this. What does it mean for the rule of law when the very people responsible for enforcing justice, people like Lindsay Halligan, are themselves deemed by the courts as unlawful?
And stand accused of being willing to provide fake legal instructions to a grand jury.
So the question you, the listener, should really mull over is this. How long does it take for an institution like the Department of Justice to fully recover its reputation once federal judges publicly view it not as the impartial enforcer of the law, but as a scammy law firm and a mere partisan operative?
That loss of judicial trust is the silent, ongoing consequence of this crisis, and it impacts every single person involved in the federal justice system, from the agents on the street all the way to the defendants in the dock.